Did you know that bringing a lawsuit in New York is a lot like boxing? You didn't? Come join me on this brief walk as I share with you why I think that bringing a lawsuit is a lot like boxing. Hi, I'm Gerry Oginsky. I'm a New York medical malpractice and personal injury attorney. Okay, what a strange analogy, isn't it? Between comparing boxing to the lawsuit process, whether it's a medical malpractice case, an accident case, or even a wrongful death case. Well, let me tell you what I mean. When you go ahead and bring a lawsuit, the injured patient, for example, in a medical malpractice case, is the one who throws the first punch. We have to first evaluate your case to see whether or not your case has merit. If a medical expert confirms that, yes, your case does have merit, now we are the ones who throw the first punch. And that's a powerful punch. So using the boxing analogy, yeah, we are the ones who take action first. We are the ones who go ahead and maneuver first. We're the ones who set up that punch, and now we throw that jab. Now, what does that mean? We are the ones who go ahead and throw that first jab, and then we throw the right cross, and now we throw the hook. And what does that mean? It now means the defense has an opportunity to go ahead and respond. Just like in boxing, you have two boxers who are squaring off in the ring, right? The first one, somebody throws a punch first. The second boxer, the opponent, now has to do something. He has to react. Either he's going to slip, he's going to bob, he's going to weave, he's going to do something, or he's going to reply in turn by throwing his own punches, right? That's exactly what happens with the defense. They're going to go ahead and do the same exact thing. And the way they do that is by responding to the allegations in your lawsuit. Now, how do they do that? Well, when we start the lawsuit, we go ahead and prepare a set of papers called a complaint. Now, the complaint lists various allegations against the doctor, for example, in a malpractice case, about how he violated the basic standards of medical care, causing you significant harm and injury. Now, in response, now remember, he's setting up for that response. Either he's going to parry it, either he's going to slip it, he's going to duck it, he's going to do something, or he's going to counterpunch. So in response, the defense turns around and says, hey, why are you suing us? We did nothing wrong here. And if we did something wrong, guess what? So did you, Mr. Patient. That's a counterpunch. Or he says, listen, I didn't do anything wrong, but if I did something wrong, whatever I did not cause or contribute to your injuries. That's a parry as well, right? They're slipping that punch. It's like, hey, don't blame me, but if I did something, whatever I did didn't cause or contribute to your injuries. And then the defense says, okay, if I did something and it caused you harm, guess what? Your injuries really aren't as bad as you claim them to be. So these are the punches, the slips, the parries, the counterpunches that come when the defense answers the allegations to your lawsuit. So every single thing that goes on during the course of the litigation is as if you've got two opponents in the ring. Somebody's punching, somebody's counterpunching, somebody's parrying or slipping that punch. And you should know something else. During the course of the lawsuit, once the case is underway, the defense will do everything in their power to sidetrack your case. Now, what do I mean by that? I mean that they will try and get the judge to throw your case out based on procedural issues, on defects that may occur. And there could be many different reasons for that. The defense will also likely make a motion for summary judgment to try and get your case dismissed on the merits, saying that you have no basis to bring a lawsuit. They're not just going to stand there and accept what it is that you're throwing at them and take it on the chin. Have you ever seen two boxers in a ring where one of them just stands still and says, okay, go ahead, hit me with everything you've got? No, that's not how it works. Boxing certainly doesn't work like that, and neither do lawsuits. So you'll never find in the ring two boxers where one of them is just standing there and getting hit left and right, and he's just letting the guy punch him. That's not what happens. Instead, the opponent is going to do everything possible to slip that punch, to parry it, to duck, to counterpunch, to aggressively go after them. And now, same thing happens in your lawsuit. So don't be surprised if the defense makes every effort to get your case sidetracked, to delay things, to slow it down, to get your case thrown out. Why? All because that's what they're supposed to do. All because that they view this as somewhat of a battle. And the defense isn't going to sit there and take it on the chin. They're going to maneuver. They're going to do things that are going to slow us down, sidetrack us, and yes, possibly even request the judge throw your case out. So why do I share this great information with you? I share this with you because it's a beautiful day today, and I wanted you to join me on this walk as I talk about why boxing is a lot like bringing a lawsuit. The only difference is there's no physical interaction, but instead there's significant repercussions when somebody parries, when they move, and there's a legal maneuvering going on. So I realize you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.